Call the list.
GL number 1.
I appear for the school. Due to some personal difficulty, Mr. Sannal has not come today, my lord.
But I never oppose. Firstly, senior counsel, my lord, I never oppose. But I will oppose. I had a personal difficulty for a bereavement. I left court and he did the matter. He made arguments. No, I am not asking your lordship. I am praying one indulgence. There is no scope for any interim order. Kindly direct affidavits. I have to file an affidavit.
Mr. Rai, that is, according to Mr. Sannal, he would be praying for an interim order.
Right?
That is what Mr.
Somebody-
Sannal said, because virus has been challenged. Virus has been challenged. I was also of that impression, but according to Mr. Sannal, even leaving aside the issue of virus, so he has a right to pray for an interim order.
He has a right. Kindly consider only one aspect of the matter, that not in service for more than 2 years. Last 2 years.
No, but
Writ has been filed belatedly.
yes, I
So
appreciate,
therefore,
but
my lord,
I appreciate because that has to be in presence of Mr. Sannal, because Mr. Sannal's argument was that yes, that order of, I think, resignation due to long absence
team
or so,
resignation.
it was long back in 2020 or 2021.
Yes.
But since the order of transfer was in force till the date of passing the judgment in those batch
Other
of
matters.
matters. So according to him, that is the cause of action that affected his rights,
Correct.
for which that is his submission. So
This
he will
submission,
be
but
also getting an opportunity.
there was, be that as it may, my lord, they had filed 4 writ petitions and we had filed 1 writ petition. Your lordship decided the matters all together. In none of the writ petitions, there was any interim order that no, for all these years, you don't have to go to school.
That, yes, Mr. Rai, that will be considered. So, if you want, you can make your affidavits ready. I'm not passing any formal directions. You can make your
I
affidavits
require
ready.
some time for that.
Yes,
Your lordship keeps it whenever, my lord, it is convenient for your lordship. My lord.
I am praying for not this week because for tomorrow is uncertain and Wednesday, Thursday, any day Eid festival may be happen, madam. So let it be not this week, madam.
so an accommodation has been prayed for on the ground of Mr. Sannal, honored advocate for the petitioner. আচ্ছা ওটা ঘুরিয়ে লিখুন, Mr. Baril, honored advocate appearing for the petitioner, prays for an accommodation on the ground of Mr. Sannal, learned counsel. So stop. Mr. Royal, honored advocate vehemently opposes the prayer for adjournment. So stop. However, for the ends of justice, the hearing of the matter stands adjourned. Mr. Bari submits that this matter may be listed in the next week. So stop. In view of such prayer, list this matter in the next week. For the ends of justice, in view thereof, list this matter in the next week under the same heading. Yes, call the next matter.
Item number 2. Item number 3.
3 yes.
My lord, this is my application.
Item
At
number
the presently, my lord, there is a possible talk of settlement going on between the parties.
specific performance of contract, my lord, as suit filed. Now, my lord, third party interest has already been created. Now we are trying to settle the matter out of court, my lord. If you kindly adjourn for 2 weeks, my lord.
What is this? What is the interim order? Which is
The
the, what is the impugned order?
Interim order, my lord.
Impugned order. Impugned order.
Oh, impugned order,
My lord. Appeal, trial court granted injunction. Appeal court reversed the same.
reverse the same.
Against that, this revision has
This
been
revisional application has been filed.
kindly keep adjourned for fortnight. In the meantime, possibly matter can be settled.
It has been uniformly submitted by the learned advocates for the for the respective parties that a talk of compromise is going on between the parties. The learned advocates jointly prayed for an adjournment, jointly prayed that this matter may be fixed after 2 weeks. So stop. In view of such prayer, list this matter. আজকে কত? আজকে 25th of April 20.
Great.
Item number 4.
Lordship, item number 4, I am for the petitioner Lordship, led by learned advocate Mr. Sobhasachhi Mukherjee. Lordship, I am praying for only 1 day accommodation. My senior is very ill, Lordship.
Where is Mr. Mukherjee?
He is suffering from high fever, Lordship. I am praying for only 1 day accommodation.
Adjourned on the last occasion as well, my lord. My suit for eviction. My suit for eviction. I'm the plaintiff landlord.
What is the impugned order?
One of they filed an application under 7172 that was rejected due to their non-appearance for a prolonged period. After that, they filed an application under 151 for recalling the said order. That application was turned down. Against that order, they have come.
Where is the order number 41 dated 24th of January 2023?
My lord. Order probably the supplementary affidavit, my lord. That order number 24th of January is at page 6 of the supplementary list. Supplementary affidavit.
Yes, what do you say? This was
This is a
dismissed for default.
suit under section 106.
Suit under section 106.
106.
So according to you, 7.1 and 7.2 does not lie.
Does not lie at all.
Let it be, but it was dismissed for default. Let it be restored. Let it be hard on merits. I'm allowing this, otherwise your suit will get delayed.
With the observation that the plaintiff averts that the suit is under transfer of
Yes,
property.
yes.
Madam, may I place the paragraph of the plaintiff for your lordships? My lord, kindly comes to page number
Give me a minute.
12. My lord.
Yes.
Kindly comes to page number 12 of the revisional application. And the 12 is the type copy. My lord, kindly see para number 7. As per scope and ambit of the West Bengal, my lord, got it?
Yes, yes.
Of the Premise Tenancy Act, the tenancy cannot be guided as per provision of the tenancy section 3.2. The rent was 3,300.
Now, as per the Act of 1997, it cannot be guided for more than 3,000. So suit was filed under the Transfer of Property Act. And the notice to quit was also served under 100.
What is the rate of rent?
Rate of rent 3,300.
And what is the
3,000.
3,000?
Calcutta and Howrah is 6,500. And the entirety of the West Bengal is 3,000. My lord, I'll place the.
You have a copy of the
Yes, yes,
premises here.
Exemptions. my lord. May I pray for one more thing? The plaintiff landlord, original landlady died. We are the legal heirs. Now, my lord, they are also at the age of 70 almost. My lord, they are suffering from various ailments. My lord, only
What
pray,
is the next date fixed in the suit?
well, I am inquiring from the CIS. My lord, only pray for an expeditious disposal of the application and the suit
First,
itself.
the application is to
And
be
the suit
disposed
is-
of. Kindly ascertain what is the next
I
date fixed. Ashwin. The no, this application under Article 227 of the Constitution of India is at the instance of the defendant and is directed against an order number 47 dated 27th of April 2023 passed by the learned civil judge, Junior Division, First Court at Barasat in title suit number 309 of 2009. In connection with the states, the opposite party herein the predecessor in interest of the opposite party herein filed a suit for recovery of khas possession, arrears of rent and mint profits, being title suit number 309 of 2009. The petitioner herein filed an application under section 7.1 and 7.2, filed applications, separate applications under section 7.1 and 7.2 of the West Bengal Premises Tenancy Act 1997.
If my lord even sees the 151 application, not a single
The
word.
the learned trial judge, by an order being number 41 dated 24th of January 2023, rejected the applications filed by the petitioner herein under section 7 within bracket 1 and 7 within bracket 2 of the said act, upon observing that the petitioner herein, who is the defendant in the suit, is not interested in the disposal of the said applications. Thereafter, the petitioners filed an application under section 151 of the Code of Civil Procedure, praying for
There's another anomaly my lord would find.
praying for recalling of the order number 41 dated 24th of January 2023. So, the said application was rejected by the impugned order. The learned advocate appearing paragraph. The learned advocate appearing for the petitioner submits that you have taken out an application under 7.3.
That's the anomaly I was pointing. I have already informed my learned counterpart in the court below too. The order has been passed in the 7th without at all seeing the plaint. An order of striking out the defense already has been passed. My lord kindly sees there.
Has been passed.
Has been passed. I just now after seeing the brief, I realized that this is a. My lord kindly comes to supplementary affidavit. My lord, the order is there. Or supplementary affidavit. Page
The
number
learned advocate
7.
appearing for the then what is to be done with that?
Has to be recalled. The order is wrong. It cannot be.
So can I record your submission?
No, my lord. Kindly does not record my submissions, my lord. Kindly pass necessary orders, my lord. And I've already informed the learned counterpart.
When the order under section 7.3 was passed, prior to that revision application was filed.
No, they came in September. The striking out of defense was in April. I was trying to point out, but my lord, since my lord took a lenient view,
Order striking out the defense was in
page number 7 of the revisional application, my lord, of the supplementary list. Page, order number 48, 16th of May, my lord.
page.
7 of the supplementary.
No, this is the order under section 7.1 and 7.2.
No, my lord. Today is fixed for hearing of 7C petition and filing page 7 of.
Sorry, 7. I was looking at page 6. Yes. May, 16th of May. No, this revision application was filed prior to that.
No, my lord, kindly comes to the page of the affidavit of the revisional application. 5th September, not at February. February was cut off.
Oh.
September, my lord.
Yes.
Can it be?
I was.
My lord, I even saw the February 1st. Their approach, I'm not saying anything, but what can be done?
Then let Mr. Mukherjee come
My lord,
because
my lord,
there will be complications.
my lord.
And you also take instructions what to do
I have
with that
already,
7-3.
I have already informed my learned counterpart in the court below that
So
this,
you have already informed, but if your stand of this, that 7-1 and 7-2 is not
does not
maintainable,
lie.
that is accepted, then that order has to go.
It anyway has to go. It,
That
because
order has
my
to go.
plane does not corroborate a
That
story.
you also take concrete instructions with regard to that. If possible, a written instructions. Because if this submission of yours is to be taken note of, then that order has to go.
Right, my lord. I'll takes it up next week. In the meantime, I shall.
And if not, this order of dismissal of 7-1 and 7-2 can be recalled even for other reasons. Could not have been dismissed in this way.
It has to be adjudicated that it had ought to have been.
Yes. So it could not have been rejected.
But I
So
could not
this
have filed
order-
the 7-3.
No. So that is why I'm telling, if you want to stick to that non-maintainability part of 7-1 and 7-2, then that order has to necessarily go. You take written instructions
Even if it's
on that,
recalled by my lord.
otherwise your suit will be delayed on this.
Even if my lord recalls the order of dismissal of the 7-1, 7-2, my 7-3 has to go anyway.
No, cannot be, because that order is not under challenge.
But
That
my,
order is not under challenge.
then my suit will go probably. I'll take instructions. My
That
lord.
is, that order is not under challenge.
Even after passing of the order, 4 months have passed, then they file the revision.
Let Mr. Mukherjee
I'll stay put
let
on
me
the next
see
occasion.
what submissions he can make on this. Thereafter, I will consider that.
No, 1st of July is the next date fixed.
1st of July.
1st of July.
All right. So come ready with those. So take written instructions on this because it will have some impact.
My lord, I've already talked, my lord.
Has to be necessarily what you have said is that 7-3 order has to go. But for that, you have to take instructions. You take instructions, concrete instructions on that. কি বললাম? After some argument, the learned advocate for the petitioner prayed for time on the ground of Mr. Mukherjee, learned advocate for the petitioner.
No, I'm also Mukherjee. I'm also. Oh, acha.
The learned advocate for the opposite party is present. First up, list this matter on this matter as prayed for by the learned advocate for the petitioner, hearing of the matter stands adjourned for the day.
For the day.
Yes, you cannot take for this week. For this week,
No, for this day. For the day. I'll inquire in the meantime. For the day.
for the day. Yes,
Or
next.
may I take back the premises tenants?
Yes, yes.
Item number 6.
Lord, the plaintiff, my lord, is the petitioner with your lordship in a suit for declaration of title and, my lord, for injunction. Revisional application is directed, my lord, not only one thing, there are 2 mistakes in the revisional application.
2 mistakes where?
Lord, the first one is in the nomenclature, the cause title part. Lord, the trial court's order has not been mentioned. Thereby, they're reversing, my lord, that part portion is not mentioned in the cause title. And, my lord, the trial court's order has been annexed and the certified copy has not been.
You don't have the certified copy.
My lord, certified copy, trial court orders, certified copy don't have, appellate court's order is there.
Certified copy of the trial court is necessary,
yes,
Mr.
necessary.
Kormkar.
Lord, that's at a tule dito.
Why are
But
you
these are the
allowing
two
this practice to continue?
Lord,
Because this revision application was filed long back.
yes,
You
Lord.
could have asked your client to obtain a certified copy.
Lord,
Yes.
পরশু কিন্তু আমি নেই। Lord, I'm okay, তুমি বলো।
My lord, in this matter, Mr. Sanjay Mukherjee is appearing on behalf of opposite party, my lord.
Who is appearing?
Mr. Sanjay Mukherjee is appearing on behalf of the opposite party. He has called me now, my lord. He has requested me to request before your lordship to fix this matter on Thursday, my lord.
He has not
Thursday.
come.
But Thursday is a
Yes,
holiday.
some personal difficulties
Thursday is a holiday.
or Friday, my lord.
It takes it up on Monday.
Tomorrow?
That is.
I shall inform, my lord. Kindly.
What is this matter? Mr. Kormakar, what is
Lord,
this?
the issue is with respect to an illegal construction being constructed on one of my encroached area,
One of,
encroached portion.
adjust the microphone.
One of the encroached portion within,
Encroach.
yes, is encroached.
Who has encroached?
Lord, the defendant. Lord, in favor of the plaintiffs. The whole case of the defendant is that the suit property is a Thika property and the same has been decided and affirmed by the learned third Munsef such and such, filed certified copies such and such. But the said document might go against the defendants. Let me explain. As it is known that West Bengal Thika Tenancy Act barred the jurisdiction of civil court where the collector has been given the power to deal with issue of Thika property. Making any declaration as to the status of the suit property as Thika property is specially barred under such and such. But if it is already settled that the suit property is a Thika property, then where is the bar? The court then can deal with the property if there is no requirement to declare the status of the property or the status of the defendants in respect of the
You
suit
have
property.
the West Bengal Thika Tenancy Acquisition and Regulation Act with you. I think bar is with regard to any matters,
Lord,
not with regard to declaration. Declaration part is also there.
Lord, previously, before the amendment was,
I want to keep the mentality issue open at
Open.
this stage.
yes.
Can it be done? Injunction without deciding the mentality, even prima facie.
Lord, the appeal court did not get into all these. The appeal court straight away said,
But trial court's order can be faulted on this ground itself.
Lord, they have not
Because
acceded.
you are relying upon trial court's order.
They
No,
have
you are relying upon trial court's
yes,
order.
yes, yes.
So this order can be faulted only on this ground. Injunction could not have been because the mentality issue has not been decided.
Lord, may I indicate section 21 once? No civil court shall have jurisdiction to decide or to deal with any question or to determine any matter which by or under this act is required to be or has been decided or dealt with or which is to be or has been determined by the controller.
Any question.
Any question, Lord, which the controller can decide.
Yes.
Now, Lord, the powers of controller is at section. The controller and any person deciding any appeal from his order shall have all powers of civil court. The controller may transfer a proceeding, deputy such and such.
This section 5, I think, 5 or 8.
The controller may, Lord, subsection 6, section 11, subsection 6.
Yes.
The controller may, for causing delivery of possession,
No. Give me the act.
I'll just
Give me the act.
just have to. Reading novel. No, perhaps not section 11 is the appropriate plot because section 11 was subsequently amended and thereafter, Lord, the adjudication power was granted to the controller. Initially, subject to correction, the controller did not have a power. Initially, the controller did not have the power of
Not have the
adjudication.
power.
It was
Thereafter, it has-
subsequently,
initially the civil court could declare
Yes.
whether it's a Tika
Yes.
property or not.
Lord, subsequently 2001
2010.
was
The amendment
amended.
came.
Amendment. Lord,
Yes.
that's section 11.
Yes.
Civil court was
All
empowered.
powers of a civil court requiring the discovery. No, this is the transfer of
Yes,
proceeding.
Lord, kindly travels after that.
Yes.
With effect from 2010, my lord.
No, sir. Amendment.
Yes.
So section 11, subsection 6 perhaps is the appropriate note provision.
This is with regard to the delivery of possession.
Yes. So, my lord, all powers, I will make this submission. My lord, all powers perhaps is not available with the controller.
How it has been dealt with by the appeal court?
The appeal court says 1981 Act was repealed by 2001 Act. That's why we don't have a prima facie case. Certified copy. Revision কেন? এতদিন revision চেম্বারে কাজ করছিস।
So here the issue is not as to whether the property is a thika tenanted property or not.
That is exactly what the trial court has held.
Yes,
The trial court says that it is a thika property, it has been declared.
yes.
Now there is nothing to be decided. Only whether a construction that is legal or illegal, that is to be
So
decided.
according to you, the controller do not have jurisdiction to decide that.
Yes.
Show me how it has been dealt with by the.
So it kindly comes to the internal page 3 of the Millard Appellate Court's order.
Yes.
Section 27, I'm sorry. Not the
I've got that.
third last.
I'm at that paragraph. Yes. you can proceed.
Section 27 of 2001 Act prescribes that with effect from the date commencement of the Act, the such and such shall stand repealed. As such, the plaintiffs failed to make out a prima facie case. Lord, where is, Lord, how 2001 Act repealed 1940? Lord, how is that to be related to this suit? Lord, I fail to understand. But then again, few things are very important. Lord, which came up during these proceedings. I have annexed. They have the record of rights in their name recorded as Bastu, as Rayot. They have a mutation order. Lord, I have issue supplementary service copy. Copy service.
Those are with regard to as to whether the properties are thika tenanted or not.
Yes.
This court cannot go into that because that has been decided.
Lord, I'm not for a second asking.
So
Lord,
now the issue is
why
with
I'm
regard
trying to indicate this, Lord, to demonstrate the malafide going on their part, to show that I have some prima
what
facie
is the
case.
prayer in your plaint?
Prayer in the plaint, your Lordship would straight away come to page 26. Deed of decree for declaration that the plaintiffs are lawful owners and co-sharers of B schedule. That is not the one kata, which I say has been encroached by them. And permanent injunction restraining defendants, including men and agents, to stop making construction on that particular portion. Kindly turns over, Lord, B schedule. A is the property in which they are claiming to be in occupation. Although they are not in occupation, through some developer they are developing. This 4 kathas.
Where is your allegation of encroachment? Which paragraph?
Lord, encroachment not in so many words, but then again they are making construction. That is the.
You have not prayed for recovery of encroachment.
Lord, I know. Lord, that's the reason recently Supreme Court in one of the judgment has, Lord, indicated that non-asking of recovery of possession does not make a suit hit by section 34. Lord, Justice Tandon had indicated on the last occasion, akamma.
But the effect would be that you are seeking recovery of possession.
I am asking for.
Then you are hit by that
I am
11(6).
I am asking for consequential relief.
Sir,
If
for
the
the court, then that relief cannot be granted by the civil court. When admittedly that is a thika tenanted property, 11(6).
but now it is not there.
11(6).
Now I have not asked for recovery of possession.
Mr. Kormakar, that is in effect you are praying for.
Lord,
If you say, then I shall record that you will not be praying for recovery of possession. I will take your submission, accept your submission that you are not praying for or you are not claiming relief for recovery of possession. You want to proceed with that? All right.
But for the time being, my lord,
Not for the time being. What is the relief which you are ultimately seeking? It has to be from a plain reading of the plaint. Because the injunction is an interim relief in aid of the final relief. So what is the final relief that is to be looked into? Whether for that purpose you are entitled to this interim injunction.
আরেকবার এটা খুলতো পাওয়ারটা লর্ড মে আই হ্যাভ লর্ড
You can come ready with all this on all these points and take instructions whether you want to proceed without recovery or paying for recovery of possession.
that will anyhow to nobody's benefit. I'll
If that is so, 11.6 will be a bar. Civil court cannot grant that relief. If that relief cannot be granted by the civil court, ultimate relief, the question would be whether injunction can be granted in aid of that relief.
The problem here is not somewhere else. Not that they have got the property declared and got me out by declaring this a Thika property.
Because that is binding. No court can touch it. Affirmed up to this honorable court. I also cannot say that order is not. That order is also binding.
Affirmed till the lower appellate court. Affirmed till the lower appellate.
Maybe, but it's
Binding
binding,
between
it is
the
not challenged.
Binding between the parties.
Not challenged. And both the courts, even the trial court have said that it's a Tika property.
But
That,
if I may
that
argue,
finding, the trial court has also accepted, said no, and kept the issue of maintainability open. That could not have been done.
those decree has to be looked into. I don't have a copy. Lord, may I come back next week? May I come back next
Decree cannot be reopened because both the courts, Mr. Kormaka, this is on a prima facie observations. Both
week? I
the courts,
understand what is from
even the trial court has said. So I cannot go to that extent.
I understand what is following. from your
So
lordship.
after going through those, both the courts, this finding is against you. This is the concurrent finding against you. 227 cannot be interfered with.
Lord, may I come back next?
With regard to that,
Takes it up on next Monday, my lord.
why?
Permits me to come.
We are ready, Mr. Kormuka.
Right.
On they prayed for
Few-
adjournment.
Lord, few documents are required to be looked into
What
before I make my
It's only a question of law.
Lord question. I can
Because
understand.
plain and injunction application, those are on record. No other documents can help you. Because the issue
The
is
other
only with regard.
documents which I want to rely on were also part of the record. Those are the two judgments and also, my lord, the findings of the
Judgments you can rely upon, they need not be made part
if
of.
I can find out something, Lord, I have not looked into those judgments. Permits me to come back next Monday.
After some argument, Mr. Kormuka, learned advocate for the petitioner. আচ্ছা, তার আগে একটু লিখুন। The issue arises as to whether the instant suit is আচ্ছা না করে এটা একটু ঘুরিয়ে করুন তো in a suit for declaration of title and permanent injunction, the application under order 39 rule 1 and 2 of the code praying for an order of injunction restraining the defendants from making any construction over the B schedule property was allowed by the learned trial judge. Full stop. On an appeal being preferred by the petition, on an appeal being preferred by the opposite party or parties,
opposite parties.
Opposite parties herein, the learned court of appeal below had reversed the order of injunction passed by the learned trial judge. Full stop. The learned trial judge
আসবে না।
না দরকার নেই। After some argument, Mr. Kormokar, learned advocate for the petitioner, seeks an accommodation to assist his court on the next occasion. First up, an accommodation has also been paid for on the ground of Mr. Mukherjee, learned advocate, appearing for the opposite parties. First up, as paid for by Mr. Kormokar, list this matter.
Next Monday.
Tomorrow, come tomorrow.
Next Monday.
Why?
Lord, the papers are not there also.
List this matter.
And Lordship, finish this off. Lord, delivery of possession here to a thika tenant or a bharatia. I am neither of them. So, my Lord, again, perhaps, Lord, I'll try and demonstrate. Not a good case.
In the next week. Come ready with those judgments where initially the view was, or under the old act, it was that the Thika controller did not have the jurisdiction to decide as to whether the property is a Thika property or not. It was within the civil courts. Thereafter, after this act came, there are series of judgments which held that civil court cannot decide as to whether a property is a Thika property or not. Bring all those line of judgments. Division bench judgments of our court is there. I think it must be somewhere around 2003-4.
All are before 2010. All are before
3-4. 2003, 2004, all these were there.
I'll.
So I had the occasion to appear in some of the matters in the second floor of this building. Nayak আছে on the ground of Mr. Mukherjee. ওই করে দিন তাহলে Mr. Nayak, learned advocate, pays for an accommodation on the ground of Mr. Mukherjee. Yes, next.
9, my lord. I am for the opposite party.
Lordship, I am for
You
the
are for the
petitioner, Lordship.
Why?
Lordship, I am for the petitioner, Lordship. Kindly, can it be make it not today?
So it has been written not this week, your lordship's list.
It has been made not this week.
It was not this week in the last week, but still
By
it has-
mistake that is
By
appearing.
mistake that.
Okay, item number 9.
Application has already been allowed.
Oh, all right. So what do you want? Not today.
Not today, Your Lordship.
Not today, correct. Then
But
not this
restoration
week. ভুল করে
application
আছে।
has already been allowed. Application has already been allowed, my lord.
Restoration application has been allowed.
Allowed.
One of
Restoration.
24,
So can 1 of 24 has been allowed?
my lord,
Disposed
my
of,
lord.
Your Lordship.
It has been disposed of.
disposed of.
So only now the civil revision will
Civil
be-
revision is pending.
ওটা একটু দেখে নেবেন ক্যানটা অ্যালাউ হয়ে গেছে তাহলে ক্যানটা থাকবে না পরে yes call the next matter
TW will be removed, my lord. Not this week will be removed.
yes sir, not this week will be removed none appears for the petitioner at the time of call no accommodation has been sought for either for the ends of justice hearing of the matter stands adjourned for the day next
Item 12,
passover next
item 13,
My lords are here for the opposite party.
Lordship, Mr. Kormokar is appearing for the petitioner, your lordship.
yes
He's on his legs in court number 15.
My lord, we have taken out a point of maintainability. My lord, I'm led
where
by
is Mr. Kormokar?
He's on his legs in court number 15. Just a short passover may be granted.
All right let him start you are taking the point of maintainability
maintainability, my lord. My lord, I'm led by Mr. Sain. My
Mr.
lord,
Sen is appearing
my lord,
where is he he's coming
he is on his legs, my lord.
Alright, then I'm passing it over.
Grateful, my lord.
Pass over. Next.
Item 18.
Pass over.
Now 20.
Pass over.
Now 22.
Pass over.
Item number 23.
Pass over.
Item number 24.
Pass over.
Item number 25.
Pass over.
26.
Pass over.
28.
Pass over.
Item number 30.
Pass over.
31.
Yes.
My lord, respondent's advocate has requested, advocate,
Respondent.
he has requested not to take this matter.
Petitioner is not here.
Petitioner is also not.
Pass over. Yes. Next.
32.
Pass over.
33.
Pass over.
34.
34 to 36, I am for the respondent one, my appellate authority. My order has been challenged.
Your Lordship, I'm for the petitioner in this matter. This matter has come up in the list after a very long time. We required to take instructions, Your Lordship, for the petitioner. For the petitioner.
CSC petitioner.
Yes.
We required to take instructions in this matter. Your Lordship, this matter has come up in the list after a very long time.
Yes, yes. That is why I have recorded, noting that it could have been dismissed on the earlier occasion, you were not there. Noting that it has come up after a long time, I have adjourned it on the last occasion.
Your Lordship, we only pray for 7 days time. Your Lordship, we'll
Only not today I can grant, not 7 days time.
grateful. We should.
This is the old matter. As prayed for by the learned advocate for the petitioner, hearing of the opposite party.
Lord, I am for the respondent number one. Other respondent is there. Private respondent is there.
CSC is there.
My lord,
CSC is the petitioner.
CSC is the petitioner. I am for the appellate authority. My order has been
And
challenged.
You are for the
We are for the petitioner, Your Lordship.
CSC Limited.
CS.
Sanjan Mukherjee is appearing.
Yes, like I'm his junior.
Yes, he appeared, I think, on the last occasion.
Yes, sir. Friday.
Yes. So I'm passing it over. Ask him to come.
And my lord, the private respondent is also there.
Ask him to come. I'm passing it over. Yes, pass over. Next.
35.
Pass over.
36.
Your Lordship. We are also the petitioner in
Pass
matter.
over. Pass over.
34 to 36.
37.
Pass over.
38.
Pass
39.
over.
40.
Pass over.
42.
Pass over.
43.
Pass over.
45.
Pass over.
47.
Pass over.
48.
Pass over.
49.
49, I am for the respondent.
Pass over.
50.
Pass over.
Pass over.
51.
Pass over.
52.
Pass over.
54.
Pass over. Pass over.
56.
Pass over.
57.
Pass over.
60.
Passover. Passover. Passover.
Well, I'm for the respondent.
Petitioner.
I'm for the respondent.
Passover.
63,
Passover.
64,
Passover.
65,
Passover.
66,
Passover.
67,
Passover.
68,
Passover.
69,
Passover.
70,
Passover.
71,
Passover.
72,
Passover.
73,
Passover.
74,
Passover.
75,
Passover.
76,
Passover.
77,
Passover.
78,
Passover.
79,
Passover.
80,
Passover.
81,
Passover.
82,
Passover.
83,
Passover.
84,
Passover.
85,
Passover.
86,
Passover.
87,
Passover.
88,
Passover.
89,
Passover.
90,
Passover.
91,
Passover.
92,
Passover.
93,
Passover.
94,
Passover.
95,
Passover.
96,
Passover.
97,
Passover.
98,
Passover.
99,
Passover.
100,
Passover.
101,
Passover.
102,
Passover.
103,
Passover.
104,
Passover.
105,
Passover.
106,
Passover.
107,
Passover.
108,
Passover.
109,
Passover.
110,
Passover. Second call.
second call, item 12,
None appears for the petitioner. Even at the time of second call, no accommodation has been sought for either. For the ends of justice, the hearing of the matter stands adjourned for the day.
thirteen,
Well, let's appear for the
Yes,
opposite part.
we start.
Well, this revisional application emanates from an order passed by the learned commercial court.
Filed.
Well, it allow
Filed. Yes.
well, the revisional application, well, it emanates from an order passed by the learned commercial court, well, it allowing my application for condemnation of delay in filing section 34 application. Well, we say, well, this application, revisional application is not maintainable, well, in view of the categorical bar under section 8 of the Commercial Codes Act. Well, may I just place the provision, well, 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 it has the
Yes.
but the provision states
Section
well, it's section 8.
8.
My lord. Bar against revisional application or petition against an interlocutory order, notwithstanding anything contained in any other law, for the time being in force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction. My lord, my case for condemnation of delay, my lord, was on the point of jurisdiction. And it shall be raised only in an appeal against the decree of the commercial court. My lord, so, my lord, if the parties are aggrieved, my lord, they can take these points, my lord, in the section 37 stage, not through an interlocutory application. No, not through this revisional application. My lord, similar circumstances, my lord, has been dealt with by the Honorable Delhi High Court, my lord. May I just place, my lord, the order?
Yes.
But we have to keep in mind, my lord, the objective of the Commercial Courts Act, my lord. Expeditious disposal of the commercial matters.
Delhi High Court judge.
My lord. It's 2021, Volume 4, HCC, Delhi 201.
Yes.
Well, its facts are very similar. I'll just take paragraph. Well, it's para 1, gives the factual background. Well, may I please? The present petition under Article 227 of the Constitution of India impugns the order dated 2nd of March 2021, passed by the Commercial Court Southeast District, Saket, New Delhi, in arbitration petition number such and such, whereby the application for condemnation of delay in refiling the Section 4 petition on behalf of the respondent has been allowed subject to cost. The order impugned was identical. The delay in filing Section 34, was allowed. Then kindly take.
So what is the delay? That's beyond that period.
No, the delay, in my respectful submission, as has been held by the learned commercial court, is of that 30 days. 90 days plus 30 days, That 30 days, can be condoned. And my delay, is 29 days in filing. We have made out an alternative case. But that is on merit, So my point is, we cannot get into the
Issue is, I say there is a delay of 34 days. They say there is a delay of 29 days. If there is,
according to you, it's beyond that 30 days.
yes. If it is
Why
29
this
days,
discrepancy on facts?
yes. No, discrepancy of fact is because they are saying that there are two situations provided for Section 34, this limitation part. One is when the award is passed. If the award is passed, then when the award is received, from that point of time, the limitation will begin. But in case of Section 33, where there is some correction or some changes have been made in the award, in such a case, from the date of the passing of that order in Section 34, not on service, they are calculating from the date of service. I am saying from the date of passing of that order, it has to be reckoned.
So there is also a dispute on facts here.
On this part only, nothing more
Yes.
than that. Only on this part.
So how there is
the dispute on facts. The dispute is on calculation
yes, yes.
from which.
So
that's the
factual,
dispute.
what is the length of the delay? There is a dispute between the parties.
The length of delay is 4 days, but
according to you,
according to me,
according to him, no.
he says
It's within the 30
30
days, which
yes.
can be condoned.
Yes, yes.
According to you, it's beyond 30 days.
Cannot
that
be.
part cannot be condoned.
That is.
So it's the jurisdictional part, whether the court at
Yes.
all has jurisdiction.
Yes. I'm great.
Yes.
While deciding the issue on regarding calculation of delay, either way, the court has the jurisdiction. We can't say, the court has no jurisdiction. I'm not addressing your lordship for the timing on the merits. I'll just address your lordship on the point of law. It's kindly.
Yes, you are placing this judgment. Do you want to place any portion of the judgment
My
apart
lord,
from paragraph 1?
I will.
You can place it. Yes.
It kindly takes para 9.
Para 9.
And 10, the operative part. I'll not trouble your lordship with the entire
Yes,
judgment. In para 8, the Honorable Single Judge had discussed the order passed by the Honorable Division Bench in a different matter. The above observation of the Division Bench are fully applicable in the facts and circumstances of the present case. In the present case also, if it were not a commercial matter, the remedy of the petitioner against the impugned order would be to file a revision petition under Section 115 of the Code of Civil Procedure. However, the said remedy has been barred under Section 8 of the Commercial Courts Act 2015 in respect of commercial matters. Therefore, the scope of interference by this Honorable Court in the exercise of jurisdiction under Article 227 of the Constitution is extremely narrow and limited only in respect of orders that are patently lacking inherent jurisdiction. This is not a case where the impugned order was passed by the commercial court without inherent jurisdiction. Well, at the next para. In the present case, the commercial court has exercised its jurisdiction and allowed the application for condonation of delay filed on behalf of the respondents. Even though there may be some merit in the contention raised on behalf of the petitioners with regard to the non-est filing, that cannot be a ground for this court to exercise jurisdiction under Article 227 of the Constitution and interfere with the decision of the commercial court. This would completely frustrate the objective behind the Commercial Courts Act, and that commercial matters should be decided expeditiously and party may not challenge interlocutory order passed in the proceeding except those which are specifically appealable. In view of the above, no ground for interference by this court is made out in exercise of jurisdiction under Article 227 of the Constitution. Well, it's similar facts. The court had, well, it applied its discretion, allowed the condonation application. The Honorable High Court has chose not to interfere with this order under Article 227. My lord, my respectful submission, in similar facts and circumstances, my lord, this order, my lord, cannot be interfered with by invoking Article 227. My lord, this order also discussed, my lord, deep industries, my lord, which is in the context of Section 17 of the Arbitration Act. My lord, the objective of the Commercial Court Act, my lord, should not be interfered with. The order was passed on 25th of August, and well, we are in April 2024. We have already delayed the proceeding for almost 1 year.
Yes.
My lord, the order records at paragraph, my lord, 30.
13.
My lord, para 8 in the second part, my lord, para 30, deep industries, my lord, is quoted. That is in
Yes.
the context of Section, my lord, 17 of the Arbitration Act.
Yes.
Well, just, my lord, I'm led by Mr. Sen. Swami,
Yes, Mr. Sen.
Here, the point is Section 8 of the Commercial Courts Act. In case of Section 8, to what extent constitutional power under Article 227 can be maintained? Now, it is too much to, we can justify this by saying that it is a constitutional provision. It is wider than the scope of provision. But the point remains that can, in the garb of this argument, every order can be challenged by way of a nomenclature under Article 227, invoking the constitutional remedy so as to negate or render the purpose of a special act,
Commercial Courts Act.
actually infructuous. Well, that is the issue, because whenever I will say if the legislature has in its wisdom incorporated this provision with a purpose, that if every interlocutory order which is otherwise not appealable under the Commercial Courts Act, and not appealable because not appealable under the Code of Civil Procedure. It's not that right of appeal has been specially taken away. Right of appeal has been taken away to the extent that I cannot challenge the order on the basis of invoking the latest patent. But whatever is appealable under the code, that appeal has been preserved. Apart from those appealable orders, the intention of the legislature was that all other interlocutory orders should not be made the subject matter of a revision before a court of revision. Purpose is because it is a special statute. Special statute has been enacted. Other provisions, if I show your lordship, that there is a specific time limit prescribed to each stage, and special provision has been engrafted for expeditious disposal of certain classes of matters which have been categorized by the legislature as a commercial dispute. So we have to keep in mind, while reading Section 8, reconciling Section 8 with power of constitutional review under Article 227, that Section 8 excludes revision only with a view to give effect to the ultimate purpose of the Act. So if we keep in mind the ultimate purpose of the Act and we interpret Section 8, then this argument that this is a constitutional power which the petitioner is invoking, that has to be taken with a slightly pinch of salt. We will have to strictly observe whether this order can strictly form a subject matter of a constitutional review under 227, or it is a guise of review under 227. If the court finds that it is actually a revision in disguise, then we must give effect to the provisions of the Commercial Act. And the bar under Section 8 must yield to the constitutional provision of Article 227. This is, my lord, the summary of my submission. And on this basis, I will refer to your lordship a judgment of the Delhi High Court. Oh, Delhi High Court,
Yes, you can place it in your own way if you want to give stress on any portion of that judgment.
Just show your lordship, my lord, the Delhi High Court judgment once.
Para 8.
Your Learned Junior has placed paragraph 9, and as well as paragraph 8.
Kindly, therefore, note just what was the issue involved here.
Yes, issue has placed paragraph 1.
Very good.
He has said that the facts are similar in this case also.
Yes, yes.
And he has placed paragraph 8 and 9.
Yes.
Wherein the deep industries
Industries have been referred to. Now, kindly just come. This line, your lordship will kindly just note paragraph 8, which quotes paragraph 30, last 4 lines.
Yes.
So, Article 227 is a constitutional provision which remains untouched by non-obstante clause 5. There, clause 5 of arbitration clause was being referred to. Though petition, but what is important to note is that though petitions can be filed under Article 227 against judgment allowing or dismissing first appeals under Arbitration Act, yet High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy, so that interference is restricted to orders which are patently lacking in inherent jurisdiction. So here we can call out one of the tests where court can invoke or court can rely upon the 227 power invoked by the petitioner only in cases which, in respect of orders which are patently lacking in inherent jurisdiction. So if the authority has exercised jurisdiction over a subject matter over which it does not have jurisdiction under the statute and passes an order, then we can say that constitutional court can exercise jurisdiction to correct that error because error has been committed by the court below in exercising jurisdiction because it does not have. So it will therefore actually, if an order is actually without jurisdiction, it will not be an order under the Act. That can be another argument. Why 227 will be invoked and will be entertained? Because that will not be an order in exercise of jurisdiction under the Act.
So if it is without jurisdiction, according to you, that cannot be termed to be an order passed under the Commercial Courts Act.
Here I am saying whichever Act. Arbitration Act or
In your case, it's not an order passed under the Commercial Courts
Act. And therefore, the exclusion of power of revision will not apply. Court can entertain a 227 and correct the error. So therefore, the test which follows from one is it has to be patently without jurisdiction. Suppose I have the authority has a jurisdiction to exercise on a 34. It has not appreciated the grounds of delay or the objections to the delay which the other side has raised. And though according to the petitioner it should have been beyond 120 days, but the court felt on calculation, no, it is coming within 120 days. So therefore, that cannot be an error inherently lacking in jurisdiction. Suppose it has exercised jurisdiction in respect of matter where there is patently no arbitration agreement. Then it is outside the scope of the Arbitration Act. So here, what is therefore to be examined?
Mr. Sen, what would be your submission? Let us take an hypothetical case where the delay is or it was filed beyond 120 days and the court accepted.
Question is
within 120 court has the power. 90 is the period, 30 days is the time period which can be condoned or can be extended in whatever way. So 120 within 120 or from 191 to 120, it's the court can exercise jurisdiction. But if the delay is, let us suppose it is outside 120, it's 121 or 122, and the court allows such prayer for condonation. What would be your submission with regard to that? Can it be said to be an order without jurisdiction or?
Then it is appealable.
No, I am on jurisdictional part. Appealable is in all cases.
No,
but on the jurisdictional part, appealable, Mr. Sen, appealable is an order passed with from 91 to 120 condonation. That is also appealable, according to you. That can be challenged in appeal. 91 to 120. Court has the power, but it's not automatic. It's not that. So that order can be challenged in appeal.
Only thing is that.
But if it is beyond 120, whether that is.
Court does not have the power to condone the delay.
No, let us suppose court condones. What would be the remedy in that case? Court does not have the power, but court passes an order.
I have appreciated point, but what is
this is a hypothetical. I am not on this.
But here, kindly see, if the court condones the delay beyond 120 days,
which it does not have power to do so,
and decides the matter one way or the other,
yes,
then obviously there is no question of the court can then obviously it is a question of an appealable order. It is not that the petitioner is without remedy.
No, that is one part.
It is appealable. Here I
follow your argument.
And in ground of appeal, I can take the point that the order is without jurisdiction. Here the difference is, here court has condoned the delay and set it for hearing on merit. So the question is whether in doing so, it has acted without jurisdiction. That is the issue.
Show me the impugned order with regard to this. How it was condoned.
Yeah.
The factual part with regard to the delay, kindly place that portion.
Yes. But I think a short list of date on the point of this.
দেওয়া ছিল দাদা আগে
দাঁড়াও, তুমি দিয়ে থাকো। First date is kindly note 28th of July 2022. Arbitrator passed an award holding the reference against me, against my client. 20th September 2022. Opposite party was informed that an application under section 33 for correction of the award dated such and such was filed with the learned arbitrator on September 7, 2022. What is very important is the next date, 27th September 2022. 33 hearing concluded and order was reserved. Subsequently, order dated 14th October 2022 passed therein was eventually served upon the opposite party hearing to speed post on 17th October 2022. So this is, according to me,
From 17th of October 2022, the time will start running.
this is one argument, my argument also.
Yes.
But this was my alternative argument. Based on this, I filed the section 5 application.
Based on the 17th of October.
2022. Now,
So on this,
my first, let me show you, Lordship, what was my first case. This was my alternative case.
yes,
I had argued why. Kindly note, in this order, I will show it from the petition also, 14th October, where he corrected the award. Arbitrator corrected the award on 14th October. We were not present, it was served later. But when this order was served on us, there was a line in that order that the parties will submit the original award to the office of the arbitrator
for correction.
Usually it is not done in any other award. Original award is there and the corrected award is there. Both can form part of execution or both can form part of 34.
So those are the orders which we are also passing when for correcting the orders. This order, yes.
Usually. But this case, arbitrator specifically ordered that both parties will submit the original award to the arbitrator's office for correction. So my submission was that it is only when the original award is corrected by the office of the arbitrator, it is that award and that date which would become relevant for execution or for 34. That becomes the award document. This was my first case. My alternative case was, even if you don't accept that case, the time would start from 17th of October 2022. 3 months and 30 days. From 17th October 2032, the learned judge did not accept my first case, accepted my second case. Counting to be done from 17th October 2022.
So counting from 17th of October, it comes within that 30 days.
Within that 30 days. Condone the delay of 29 days.
Show me that operative part of the order.
May I just show your Lordship, once the arbitrator's order where he has directed that at page 75 of the revisional application. Operative part. The 33 order. Kindly come to page 75, last part, last paragraph. This is the 33 order. It starts at page 71 Kindly note the order dated 14th October 2022. Concluding paragraph is at page 75. Part
Correction order is a longish order.
Corrected order.
The
Usually
judgment
it is one page.
was totally facts in the original, the facts in the totally. The records are corrected. Parties are granted liberty to get certified copies supplied to them, corrected by the tribunal within a period of 1 month. This order.
Last line is very important. This order be circulated amongst the parties by the clerk of tribunal by speed post.
There was no dismissal within the meaning of 33 until 40.
My learned friend's contention was 14th October should be the date because that is the date of disposal of
No,
request.
so this paragraph, the records are corrected accordingly. Parties are granted liberty to get the certified copies supplied to them corrected by the tribunal through the office of the tribunal within a period of 1 month from the date of the order.
Yes.
So parties were given liberty to bring those
Original order award because original award is already
certified copies supplied to them
Yes.
to get it corrected.
Yes. Because July order award was passed, original award is already with us. I have to give the original award and where he will incorporate these corrections.
Yes.
So I have had submitted before the court below that in view of this requirement made by the
So when this was corrected ultimately?
15th of December. That is also evident from an email
76.
which I had disclosed in my
So
petition.
according to you, the time will start running from 15th of December.
That is my first case.
In your application.
In my application.
Show me your application.
Yes. And my alternative case was, even if you don't accept that 15th of December date, but the fact remains that this 33 order, which was directed to be circulated by the clerk of the tribunal by speed post, was received by me on 17th of October. So alternatively, 17th of October should be the starting date. And 3 months and 30 days, I come within that 30 days. Learned court below accepted my alternative case and condoned 29 days delay.
Show me your application. Page 82.
Condonation application.
Yes, condonation that is the condonation application. Let us show the first. In the first, I did not make any condonation because my case was 15th of December. Second case, I put it on record by way of a Section 5 application because if I...
Oh, from that it's within time. It's within 90 days.
15th December, it is within 90 days.
Yes.
16th February, I had filed.
So that is within 90 days.
90.
So if that is taken into from the date of correction, that is within 90 days.
Yes.
From the date of
Service of the 33 order.
33 order.
Not 90, but within 120.
Yes. For that, you have filed this application at page 82.
Yes.
So in this application, you must have pleaded that it was for abundant caution you are filing this application.
Yes, yes.
Show me that your original case made out. You must have said that it is within 90 days.
Kindly come to paragraph 4 at page 84.
Yes.
Pursuant to the directions contained in the order dated October 14, 2022, your petitioner has followed up with the officials from the office of the learned arbitrator. However, owing to inability of the concerned official at the office of the arbitrator, your petitioner could not get the certified copy of the arbitral award corrected through the office of the learned arbitrator before December 14, 2023.
It should be 2023 or 2022.
23.
23.
Just let me check once.
No, because this application was filed
No.
only
I
on
think,
July, so it has to be 2022.
I think it's 20.
Typographical error.
That is a typographical correction.
I think Mr. Kormakar will also not dispute this.
These are not
It has to be typographical 2022 because this application was filed in July 2023, so it has to be prior to this. Yes.
then kindly see, thus relevant date for the purpose
Everywhere, Mr. Sen, you have committed a
of
mistake.
mistake 2023.
Period of limitation filing of this application could commence from December 15, 2023.
Everywhere that mistake is there.
Yes.
Relevant date for the purpose of disposal of the said application under section 33 would be the date when the copy of the arbitral award was corrected in consonance with the directions contained under the order dated such and such. Hence, period of limitation for application 34 would commence as on from 15/2022.
It should be 2022.
Application was filed on February 16, 2023 within the 3-month period without prejudice to the aforesaid. Even assuming that period of limitation would commence from the date when the order under 33 was communicated to the petitioner, that is October 17, even then, proceeding was instituted, though not within 3 months ending on January 7, 2023, but well within extended period of 30 days, expiring on February 16, as contemplated on 34.3. There is a delay of 29 days. So this delay of 29 days has been condoned. First case has not been accepted.
Show me the reasoning in the impugned order.
Yes. I have not challenged that part, that my original case has not been accepted. It is my learned friend's challenge to the condonation of the 29 days.
Because, Mr. Sen, you cannot challenge because the ultimate relief is in your favor.
Yeah, of course.
So you can very well file a cross objection against his. Cross objection is maintainable.
34 going through.
Yes.
Findings of the court start from page 4.
Page 4.
Yes.
Yes. Show me facts you have placed. Show me the observation, how the court has.
Kindly see the 4th paragraph at page 4. Petitioner has made twofold arguments.
Yes.
Submitted that receipt of the corrected copy on December 15 should be considered to be the starting point.
Court has also committed a mistake. December 15,
It's actually
2020.
my mistake. We can't blame the court.
Yes.
Should be considered to be the starting point of limitation, then it shall be presumed that the objection application has been filed within time and further prayed for affording the benefit of the observation as made by the learned administrator at last paragraph of section 33 order. Then 33 order is quoted. Further submitted, even if assuming October 7.
So your case has been quoted here.
Yes, my case has been quoted here. Further submitted, even assuming October 17 to be the starting point, then the petitioner points out that the section 34 application has been filed after 3 months before expiry or another 30 days. On the other hand, respondent vehemently opposes the content and submits the conjoint reading of 33 and 34.3 categorically state that limitation should begin from the date of disposal of 33 application, which is October 14 and not from October 17 or December 15. After considering submission.
So this page 5, this effective second paragraph is the ultimate finding.
Effective. After considering.
After considering.
Yes.
The last 3 lines.
It is an admitted fact that the order in connection with was delivered on October 14 by the learned arbitrator of his own, but not in the presence of the party. And the parties came to know on October 17 on receipt of the order by speed post, and this court will treat October 7 as date of disposal for the reason parties were without knowledge.
So that is the reasoning.
That is
why the court accepts this October 17 to be the starting point.
That is
and the court holds that delay has been sufficiently explained.
And it is condoned.
Condoned.
Now, my point, therefore, is that it is not an order
without jurisdiction.
He has exercised his right under proviso to 34(3).
227 could not have been invoked.
It could not.
Cannot be invoked.
Cannot be invoked in view of the bar of section 8. You cannot convert the 227 court to a revision court by way of disguise and actually take away the effect of the section 8. Section 8 is there in the statute. One has to respect section 8 with all its rigors, but if you can say that this order is patently lacking in jurisdiction, that it is not an order under the act, then section 8 would not have applied, then constitutional power would have been effective. Now, if I just come back once to that Delhi judgment, Lord, I had read last part of quoted para 30 in para 8. Just kindly come to the next page. This is probably the same as this was a part of a division bench of Delhi High Court, which has been quoted.
Yes, Deep Industries.
Yes. No, Deep Industries Supreme Court. Kindly come to paragraph 8. This is a division
Yes,
bench
division bench, yes,
in Delhi, which referred also to the Deep Industries.
yes.
Thus, though we are of the view that gates of 227 ought not to be opened with respect to orders in commercial suits at the level
I've
of.
marked it. Mr. Sen, I have already marked.
I don't think I should.
Anything more?
I,
Yes, Mr. Korvukar.
Lord, with respect to Article 227 argument, that I don't have much to say, Lord, because we all know, Lord, 227 is or 115. 227 has its own rigors, and Lord, we all operate within those rigors. It is one thing.
Otherwise, then the revision court would not have 10,000, 5,000 matters.
No, we do.
We strictly
We have to
apply.
initially.
Mr. Sen, what was the object of CPC Amendment Act of 1999 and 2000? With regard to amendment of section 115, what was the object?
That is also to a certain extent cutting down
So
on.
after that, what has happened?
Nothing has happened.
Even the tribunals.
So that was the argument that all orders, and as you know, it did not be said, it's all applicable under section 105.
Yes.
Any orders passed in the suit, you can very well prefer an appeal when you are challenging the ultimate degree, what the argument which you are now canvassing.
This is a special act, so that is why.
Which you are now canvassing 37, you have all those you can
Yes.
challenge this. So that was the argument that in a first appeal, so you will be having all points or all interlocutory orders you can challenge.
One difference is that this act makes orders appealable also. Interlocutory orders.
Yes.
Interlocutory orders specifically made appealable as per CPC.
105 is also there.
Yes, as per CPC.
So identical. Even if you do not challenge, you can challenge interlocutory orders earlier in 115, now in 227. If not, you can very well challenge at the time of while preferring an appeal, any interlocutory orders you can challenge.
But where the court finds that it is absolutely without jurisdiction, then the court steps in under 227. That is the principle.
That is the plinth. That is the plinth of Article 227.
Yes. So the scope of 115 or any revisional jurisdiction under any statute, as well as 227, there is a difference.
There is always a difference.
So though it's couched at a revisional jurisdiction, but
it is actually not a revisional court. It is not a revisional because we write.
Or is white.
Under article, but constitution.
But where to be exercised.
Yes, where to be. That is the point.
Lord, may I place section 8 once for your Lordship's kind consideration? It starts with Lord bar against.
According to you, this no civil revision will be 115.
This is not 115 application.
I appreciate. So this will be your first argument.
Second is, Lord, comes to article section 13, 1(3).
So that is, I also said that cannot be in the guise of 150.
No, this is not in guise. This is not in guise.
Yes.
Kindly comes to section 13 also. Provided, appeals provided.
Yes.
What kind of appeals? Any person aggrieved by judgment on order or order of the commercial such and such, district judge may appeal commercial court division within 60 days. Any person, Lord, kindly straight away comes to the proviso. This was the original, Lord, incorporation. Thereafter, kindly comes to proviso. Provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under Order 43. So, my Lord, initially, what Mr. Shane was indicating that all orders are appealable was sustainable under section 13. But after this proviso was included in my Lord 2008.
Only the appellable orders.
Only Order 43 orders will be
appellable orders.
So I don't have an appeal. I don't have an appeal.
No, that is what I submitted also. Only interlocutory orders which are appealable under the Code of Civil Procedure are appealable.
So, Lord, I don't have an appeal.
Purpose is to strike out.
So you are trying to make a distinction that all interlocutory orders passed under the Commercial Courts Act is not applicable. It's only those applicable orders under Order 43.
Yes.
Those are
That is my
applicable.
one limb of submission. The other limb of submission is interlocutory orders which gives a finality to an adjudication or remains suspended but is not appealable. Lord, I cannot be held remediless in presence of Article 227.
Mr. Kormakar, kindly repeat your last submission.
Lord, all appealable, there might be some interlocutory orders against which appeals are not provided.
Yes.
There also might be some interlocutory orders which does not clinch the issue finally. Lord, which does not fall within 115, but still, Lord, courts go out of their bound to pass such orders. For those correction, Lord, I am protected under Article 227. Now, Lord, this issue came up for hearing before our Honorable Court. Lord, there are other judgments of other high courts also, but first I'll indicate our Honorable Court. This is, my Lord, although this is reported, but my Lord, I do not have the report.
Deepak
I'll
Polymer.
just give him a copy. Deepak Polymer.
Determining the subject matter of the commercial dispute. What would be a commercial dispute?
No, Lord, whether
No,
227
there
applies.
it has been decided what is the effect of this, if I correctly remember, because I considered this judgment in one of the judgments which I have delivered.
Lord, kindly,
Paragraph 15.
then, my Lord, I need not place this anymore.
No, you place in your own way.
Learned counsel for the opposite parties cites the bar under sections 8 of the 2015 Act, which stipulates that notwithstanding anything contained in any other law for the time being in force, no civil revisional application or petition shall be entertained against any interlocutory order or of a commercial court, including an order on the issue of jurisdiction, and any such challenge subject to the provisions of section 13 shall be raised only in an appeal against the decree of a commercial court. An analogy is sought to be drawn by the council between section 16 of the arbitration 96 and section 8 of the Act of 2015. Same line of argument. So that was dealt with by Justice Bhattacharya, my Lord, considering Surjodev Rai.
Paragraph 35.
Paragraph 35.
35. Yes.
As regards, because the other party with respect to the merits of the case, as regards the jurisdiction of this court, under Article 227 of the Constitution, the provisions of Section 8 of the Commercial Courts Act, despite its initial non-obstante clause, cannot operate as an absolute part to the exercise of the power of juridical review by the High Courts, which is conferred by the Constitution of India under Article 227 thereof, since the 2015 Act is a subordinate legislation under the Constitution, the latter being the grundnorm of the Indian legal system. Since 21C such and such, Lord, these are not
This is with regard to what will be the commercial dispute.
Yes, Lord, there
I
are
think only up to paragraph 35.
39.
39, yes.
39. No question of the bar to the revisions against interlocutory orders passed by commercial court arises in the present case.
Surjodev Rai considered.
Yes. In view of the patent jurisdictional error. So, Lord, that is the plinth of any submission in Article 227. We have to satisfy the court on, Lord, the jurisdiction has not been properly.
That has also been held in the Delhi High Court judgment.
Absolutely. So, Lord, this is.
So, Delhi High Court judgment also did not say 227 will not be maintainable.
Does not say that.
But where?
Yes.
Under what circumstances?
In whichever Article 227 we approach with your Lordship, Lord, we have to satisfy this first. Else, Lord, this can be converted into 115 proceeding. There is no difference. Now, Lord, facts are more or less admitted. I need not bother your Lordship. May I take your Lordship, Lord, to the Arbitration Conciliation Act once? Achha,
আরবিট্রেশন কনসিলিয়েশন একটা আছে কিনা দেখুন তো, নাহলে আনিয়ে নেবেন। আরবিট্রেশন এন্ড কনসিলিয়েশন অ্যাক্ট 1996 যদি না থাকে একটু আনিয়ে নেবেন। ইয়েস,
এই দীপক পলিমার জাজমেন্ট
33,
Lord 34.
34.
Yes. Section 34,
Yes,
subclause 3.
yes,
An application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award, or if a request had been made under section 33 from the date on which that request had been disposed of by the arbitral tribunal. So, my lord, there are two parts of this provision. If the order has been passed specifically under section 34, the award has been made, then it is from the date when the party had received the arbitral award.
yes.
Lord, there is a purpose of this, is a code in itself. So, Lord, it provides for everything. For a usual arbitral award, Lord, it has been provided that from the date when the award was received, because it might be a situation that the award was, Lord, ex parte passed, or the person did not contest, whatever might be the situation. That's why it consciously, Lord, indicates that on which the date on which the party making that application had received the arbitral award. Thereafter, it changes its implications when it comes to section 33. It says, if a request had been made under section 33 from the date on which that request had been disposed of, there is no question of service coming in while considering section 33. Thereafter, Milord, it goes on to
So
say
according
otherwise.
to you,
Yes.
this 34(3) specifies the starting point of limitation
Yes.
in case a correction is done under section 33.
Yes. There are two aspects already provided. The legislature contemplates of a situation, two situations. Else it could have said that wherever the party has to be served, from the date of service, it has to be recorded. It distinguishes two. Section 34, yes, from the date of usual award, from the date of receipt. But if 33, then from the date of disposal of that award, not by correction when it is made or when the party comes to know. And this provision, my lord, I do not think Mr. Shane will issue join any issue on that. That this provision, section 34, has to be read strictly.
Yes,
Even 1 day delay after 30 days cannot be condoned. That is, my lord, the law.
yes. I don't think Mr. Sen will
No,
dispute
no,
that.
But this interpretation I will
Yes, yes.
সেটা now, my lord, kindly comes to section 30.
Section
33.
Yes. Yes.
Correction and interpretation of award, additional award. Within 30 days from the receipt of the arbitral award, unless another period of time has been agreed upon by the parties, a party with notice to the other party may request the arbitral tribunal to correct any computation errors. Well, these are the nature of corrections that the tribunal is entitled to carry out. Lord, why I was indicating while reading 34(3), your lordship would see a party with notice to the other party. So the other party was never at a surprise. when he knows that section 34 has been, an award has been passed, he has to challenge it within the regards of that 90 days and my lord 30 days, 120 days, he has to challenge it. Now, my lord, it is not expected from that party that a correction will be made and he'll sit back for next 6 months when he'll receive the copy and then he'll go for filing the, challenging that award. That is the purpose. Mr. Shane had argued regarding purpose of a commercial act, commercial courts act. So, my lord, here is the purpose of arbitration and conciliation act. That the party who is a party in a section 33 proceeding will not sit back waiting for 3 months when I'll go and get my award corrected. Because the order has been passed. You have to go. You know it. You have to go.
No, order under what?
Section 33 order.
Section 33 order.
Yes.
Yes. So when can a party come to know of that order?
Lord, whenever a party comes to know, it will be reckoned from the date of disposal. That's why.
Suppose it is beyond 30 days.
Lord, here is not such case.
No, no,
It is for the regular.
So let us assume it's beyond 30 days or not 30 days, beyond 120 days.
Lord, suppose
The
the
application has been filed with notice, but it is being disposed of and communicated
after
120 days after this award is corrected. Then the party
Lord,
will be remediless because the court do not have power to condone beyond 120 days.
So that's the reason the party has to be, Lord, that much diligent.
Vigilant, Mr. Kormokar, is what vigilance you expect from a
Lord,
party
1 week.
when the order is being passed ex parte or not ex parte,
This is on notice.
without or in the absence of the parties, not any one party, in the absence of the parties, thereafter communicated. So what will be the starting point in that case?
Lord, in that case also, it has to be reckoned back to the date of disposal. Why?
Then what will happen if it is communicated after 120 days? You have to answer this.
Lord, that
So can an application under, so in that case, section 34 application cannot be filed because cannot be condoned beyond 120 days for whatever reason.
Lord, for that case, the party has to show that he was vigilant, he was
I am
diligent.
giving you a hypothetical example. What vigilance?
Let's say, for example, on 14th of October, the order was passed. And incidentally, after 4 months, the order was communicated. That is what your Lordship is not giving the situation. After 4 months, the order was communicated. Lord, then the party complaining of that delay has to show that what steps did he take.
What steps, Mr. Kormokar, I am asking you, what steps you expect a party
But that
to
is
take
the answer.
during that period?
Lord, the answer your Lordship would get in this section itself. May I?
Yes.
The arbitral award, the arbitral tribunal, section 33, subsection 3.
Yes.
The arbitral tribunal may correct any error of the type referred to in clause A on its own initiative within 30 days from the date of
That
the
is own initiative. It's
Yes.
not an own initiative.
thereafter. And Lord, subsection 2, if the
Yes.
arbitral tribunal considers the request made under subsection 1 to be justified, it shall make correction or give interpretation within 30 days from the receipt of the request.
Yes.
So the time limit has been made.
What
If
will
the-
happen if the award is or the correction is made after 30 days? What will be the effect of that award?
Not from the date of disposal.
No. What will be the, if you interpret this
So
shall
those-
as a mandatory provision, Mr. Kormokar, let us assume that upon a request, this correction is made beyond 30 days.
Lord, 4.5 is also important.
Yes.
Unless
Cases, Mr. Kormokar, what is there? Time limit is mentioned everywhere. 30 days from a request or whatever it might be. Let us assume it is not done by the arbitral tribunal within the time limit specified.
such
Or
such
how
peculiarity.
this shall, don't go that far. How this shall has to be interpreted, whether it's mandatory
No,
or
this
direct.
shall
But
has
even
already been interpreted. This shall in section 34 has already been interpreted.
Not in 34,
As-
33. This shall,
Oh, আচ্ছা,
এসছে তো
within 30 days.
1 নম্বর থেকে টিউশন করে দিন। আবার এটা 1 নম্বর কোটে ফেরত দেবেন, না হলে আবার আরেক মুশকিল হবে।
But now, my lord, your lordship knows, my lord, the section 29A has also been incorporated. The effect of section 29A is also to be considered. Not considering everything, when section 29A was
Assuming all this, can a person be said to be remediless for the fault or negligence of the court or the tribunal?
Lord, here in this present case, there is no such fault. In this present case,
So let us assume 120 days.
If they,
Beyond 120 days,
what your lordship, in a hypothetical situation, where, my lord, the arbitrator is negligent, ignorant, he serves, my lord, the copy of the date of disposal after 120 days. My lord, in such a case, because of this 30 days, the party complaining about that fault has to come up and show that he had
you do not have power, Mr. Kormokar.
not request for
Restricted
asking for the
for whatever reason.
not
Same argument to 7.2 cannot be extended for whatever reason.
yes,
So same applies here.
yes. No,
Cannot
those
be
are all gone.
extended.
Not in 7.2 also they say it's not, cannot be extended
So
for whatever reason.
here also cannot be extended. So, but there it's the fault of a party not approaching. Here it's not the fault of a party, but for the action of someone for which the court
Your lordship,
is.
what your lordship is saying is hypothetical. Lord, this is not the case
Mr.
here.
Kormokar,
But the implications will have.
Interpret a provision. You have to take
yes,
into
yes,
consideration
yes,
everything.
implication will have.
When you are saying that no, your argument is it has to be from the date, not from the communication.
And that's why consciously
Some
the
statutes, Mr. Kormokar, there are other statutes you will find in these excise matters and other things. When all these matters will be finding that it is from the date of passing of the order.
it reverts back.
From the passing of the order, but how it is to be interpreted.
Even in, my lord, our corporation appeals also, it
Meaning
goes back
from the
although we
date of the
receive
order.
late, but we file a section 5, the provision is there.
Yes, because
But here,
everywhere you will be finding from the date of the order.
But here, my lord, the situation is different. If that was the purpose of the statute, then, my lord, there was no requirement for providing two provisions separately. If the what is falling from your lordship, my lord, or what Mr. Sen is trying to argue, then, my lord, there was no requirement for this section 3 to be included separately. The legislature could have straight away written.
Anything more, Mr. Kormokar?
Lord, I have to indicate, my lord, how the section 34(3) has been interpreted, my lord.
On 33.
34(3) and 30. Yes, read with 30.
Yes.
Yes.
So on 33.
On 33.
Show me that. Because don't multiply that
Yeah.
section 34, it cannot be extended beyond
I'll
30
just
days. So cite a decision where it has been said that in a case
2009
of 33, communication is being made thereafter, but it is to be taken from the date. When the communication is.
Lord, in all the judgments, everywhere, I found, my lord, that the date of reckoning is from the date of disposal.
No, facts you have to see, Mr. Kormokar, because the facts here is important.
I'll try, Lord, I'll try. And
because 1 or 2 days, you cannot say that it was negligent here, because theoretically, the tribunal has posted it by speed post on that day itself, or maybe on the very next date, but it was received by speed post. You can take 1 or 2 days. That is the delay which exceeds these 30 days.
The question here is not about 1-2 days. They sat back till December 15 to get the order rectified, which was not. What is the nature of correction here?
Mr. Kormokar, there are 2 ways of looking at it. Yes, you can find fault with Mr. Sen's client in sitting back till December for correcting. That is one part. So that was his original argument that the court has not accepted. So you need not go that far.
I'm not going.
So now it's on the second part,
the issue of
14th or 17th.
14th. No, this is এটাই তো AIR এটা কর্ণাটক না AIR 2009 দিল্লি 41 এটা জজ সাহেবকে দেবেন দাদা
9 Delhi, page
2000 AIR 2009 Delhi, page 41. Dada. Lord, paragraph 2. To better appreciate the controversy, the following essential facts are narrated. The award
Take,
was
Mr. Kormukar, I have to rise. I have a division bench. Can you come back at 2 or 2:30? I do not know how much that division bench will continue. Mr. Sen has concluded.
I will distinguish this. Judge.
All right.
Not make
So-
that one
So we have a 3:30 today.
Yes, 3:30.
3:30 today. So can you come at 3? Mr. Sen at 3 p.m. No, 3:30. There is a reference. No,
no.
only rising.
Only rising.
So can both of you come at 3?
3.
So I'm 3 সময় fix করলাম. So that it can be completed. Hearing can be concluded. Otherwise.
appear করে গেছে। Yeah.
Item number 6.
One application for addition of party.
Why are you mentioning now?
Morning, my lord, I was under the impression that your lordship is the division.
I have fixed a matter. I sat at 10:30. So why are you mentioning now?
My lord, tomorrow.
What matter?
My lord, this is Dugapur bus stand matter.
2000?
Bus stand matter. For addition of party.
Addition of party?
Yes, my lord. Your lordship election was also there, but the matter will appear. But there are the
Writ petition? Which year?
year 1996. Yes,
Yes.
well, tomorrow, from tomorrow,
I don't know. I know for today. Tomorrow I don't know. Yes, call the 3 p.m. fixed matter.
CP signature item 13.
Lordship, Mr. Kormakar is on his legs in code number 5. A matter is going on. I humbly praise your Lordship. Kindly make it not today, your Lordship.
Why?
He's on his legs in code number 5, your Lordship. A matter is going on there.
Yes, Mr. Shen, what is your reply with this section 33?
Yes, but that is very clear. Your
It
lordship,
gives the
lordship will kindly see first. The section has to be given a meaningful interpretation.
yes.
This part has to be read with the order. This part provides that from the date of disposal of request, where the arbitrator himself says that first of all the order is not passed in the presence of the parties, both parties. It's not that one party is absent, therefore it is no. Where his order is reserved, passed on another day, and for making it known to them, he says, he gives the direction that I am going to serve it. He will serve it.
Yes.
So therefore, disposal.
But here Mr. Kormakar wants to make a distinction between the first part of 34.3. He says that application for setting aside may not be made after 3 months having elapsed from the date on which the party making had received the arbitral award. First part says arbitral award. Second part, he says it fixes from the date on which
the request is
has been disposed of.
Kindly consider this. This has to be given a meaningful interpretation. Unless the party knows about that order. And here it is evident from this order itself that the arbitrator is also aware that the parties are to be made aware of the order. So the arbitrator gives the direction that his office will serve it. So this cannot be given a interpretation that a person is not aware of the order, but limitation will go on running. That is never the purpose of. That is why when 34.3 is being interpreted, courts have always interpreted it in favor of saying that the party must be aware of the original award, not even copy. Not even copy, because I have a judgment which well settled now. Suppose a person does not receive the award from the arbitrator, and in execution, when it's filed by the award holder, he receives a copy. From the execution petition, he has received a copy. The courts have held that even from that copy, their time has not started to run for 36. Time will start running only when under 31(7) original award is served. So therefore, this has to be given a meaningful interpretation. It is knowledge from knowledge of the original order. Both 34.3 and 33 has to be interpreted in the context of knowledge of the original order. Where 33 proceedings.
Do you have any decision in your support with regard to this section 33? That it is to be also from the date
because this is an unusual situation.
That is I'm asking you for that.
No, it is,
you have any?
No, my lord. I don't, my lord, because this situation is not contemplated by the statute. statute, kindly read 30. There are so many things in 33 which have not been complied with in this case. It starts from their default. Kindly see, just kindly comes to 33.
Yes.
Within, first is subsection 1. Within 30 days from receipt of the arbitral award, unless another period of time has been agreed upon by the parties, a party with notice to the other party may request the tribunal to correct. So 33 application has to be filed
Within 30 days
within
of.
30 days. Subsection 2.
So this has been done in this case.
No, nothing has been done.
No, this.
Kindly see that my list of dates.
No, who has filed this application for
They-
correction?
They,
So that was beyond 30 days.
beyond 30 days. Disposal is beyond 30 days. Order is passed in our absence. If the order is passed in our presence, even on virtual mode, if we are present, then also disposal of request I will accept. But
Because aware, parties are to be made aware.
Made aware, that is the basis. And this departure is created by the arbitrator. Because it was not necessary for the that is what I argued before that court also, because I must get benefit of the correction. 33 says that this order is sufficient.
Yes.
The arbitrator felt, in this case, this is a special case, arbitrator felt that the parties will not act only on the basis of the order. You must bring to me the original award.
That there you have delayed.
I am
There-
not going into that, but I am
There you have delayed.
but I am saying this is a special case where the arbitrator has devised his own procedure. And if the arbitrator has carved out a procedure, the parties are governed by that procedure. Because this last paragraph, your lordship sees, of the 33, that was not necessary. Simpliciter, it could have said the correction application is disposed of. Parties
This is
would
the
have-
correction.
This is
This
the
is the
correction.
correction.
This is the correction. But my contention is where arbitrator has devised a procedure and arbitrator has said that the order be circulated. So the arbitrator was aware that 14th, nobody was aware of this order.
For that, the arbitrator felt that this order is to be circulated.
So if the arbitrator has felt that the order is to be circulated, therefore knowledge is must. If the knowledge is must to bring an action, then it has to be from the date of knowledge. But I am not arguing on the other aspect. There also I had a case, just academic, since it arose, I am just telling your lordship, my case was where an arbitrator has given a direction that the original award is to be corrected by him or his office. Therefore, no party can commence any proceeding on the basis of the original
Award.
Only on the basis of the correction incorporated in the original award. And he has given also a time. So therefore, I am not wrong in waiting and having the original award corrected.
But there you have delayed.
That is a question of fact. That is a question of fact which has to be disputed. No one has disputed that. I am not going into that. Just let us forget that. I am only saying is for interpretation of 33, therefore, one cannot take this date, disposal of request, in the special facts of this case concerning the direction given by the arbitrator to circulate. Once arbitrator gives the direction to circulate, then the date of the order is no longer relevant. And the date of disposal of the request has to be taken as the date of knowledge. Here, date of disposal was equivalent to date of knowledge, because 33 was being disposed of in presence of parties. So therefore, I had knowledge on the date it was disposed of everywhere. Yes.
Pronounced on a particular day. So until it is pronounced, it is not to my knowledge.
So therefore, and then also your lordship will see, as I said, all parts of 33, the time limit is not mentioned. Is not complied with here, fulfilled. From my list of dates, your lordship will get.
Yes.
28th of July 2022, original award. 20th September, I came to learn that application was filed on 7th September.
Yes.
More than 30 days.
No, but it is from the receipt of the arbitral award. That date is not here. 28th July, when it was received, that date is not here.
28th July.
It was received on 28th of July.
Yes, kindly see there. I don't know whether they have.
No, I take your words. If it is on 28th of July,
হ্যাঁ পেয়েছিলেন কবে সেই স্টেটমেন্ট এখানে নেই অবশ্যই that they can say when they received it. Whatever it is, the arbitrator's disposal was on 14th of October.
that was within 30 days.
No, September 7 it was filed.
No, 27th. Oh, 7th of September.
Yes, filed on 7th of September.
So hearing was
concluded
concluded.
on 27th September. Yes.
So hearing was concluded on 27th of September. So
disposed of on 14th of October. So therefore, we cannot stick to 33 disposal. That is only my reply. Order be circulated amongst the parties by the clerk of tribunal by speed post. That is the specific mandate.
yes, subsection 2 of section 33
Yes.
says if the tribunal considers the request made under subsection 1 to be justified,
Okay.
it shall make the correction or give the interpretation within 30 days from the receipt of the request. So the order has to be passed within 30 days.
30 days.
So here your case is that it was not within 30 days.
So not within 30 days. So we can't stick to all these dates because here the arbitrator is carved out a procedure. He has devised a procedure for service. If he has devised a procedure for service and his office has served me, then I will be penalized for those 2-3 days.
Yes, that is.
But even on my first case also, I think I have a point. Because
First case means original.
Original. Kindly read the last paragraph, only the last paragraph.
Of that correction order.
Correction order.
Yes.
Parties are granted liberty to get the certified copies supplied to them, corrected by the tribunal through the office of the tribunal within a period of 1 month from the date of order. Which I, at the cost of repetition, I am submitting. That means no party is empowered to rely upon this order. Parties can rely upon the original
Corrected
award.
copy only. Corrected copy.
Corrected copy of the original award. And that I have got on 17th of December, 25th of December. And I have explained that delay also. The tribunal office was not available. There is no denial to that. So question is, why should the 34 court not consider this mandate? I have relied upon a mandate of the tribunal. Why should I be penalized for obeying an order of the tribunal? So your lordship said that.
So in a case, whatever may it be, whether this special procedure was
necessary or not, I am not going into
that. Even in an ordinary case, let us assume that the arbitrator says, this corrections is being made. That rider portion was not there. Let us assume that case. So even in that case, both has to be challenged. Initial award
and the corrected
as well
order.
as the corrected award.
The corrected order.
With the corrected award. So in effect, let us assume that by this correction has to be the original award gets modified.
Gets modified.
Some way or the other.
Yes.
So if it is modified, so it's the modified award which is to be challenged.
But usually what
So
happens
if
at
that is so, so it is an effect, limitation under 34 that from the date of service has to be
incorporated there.
cannot be
Because
33
cannot be
because
33.
33 alone cannot be challenged.
It has to be read as incorporated there. So when in 34 the legislature has said it is knowledge from the date of receipt, 33 has to be given a similar interpretation. And here my case is completely different. I cannot be penalized for obeying the direction of the tribunal.
Yes. And what do you say to this Delhi High Court judgment which you are citing?
Delhi High Court, I am sorry to say, but the law has changed completely after 2009. The Lordship will see the 2009 Delhi, which my learned friend just now showed.
Yes.
This is not so with the greatest of respect. It is not considering
So what was held?
the.
What was held herein?
First, kindly see paragraph 2.
Yes.
Essential award was announced. Kindly note, announced on 18 January 2005. Arbitrator at that stage communicated copies of the awards to the parties.
So when it was announced, immediately communicated.
Copies, not original.
Copies of the award.
Copies of the award. He, however, recorded that original award was not being communicated.
Yes.
Since it had to bear the prescribed stamp duty.
So only the decision or copy has been communicated, not the formal award.
Even it's not even stamped.
Huh.
The claimant was directed to ascertain the required amount and send the stamp papers to enable the arbitrator to have the award imprinted on it. On 12th February 2005, petitioner moved the arbitrator for clarification, correction, interpretation of the award under 33. Among several contentions, not necessary, 4 lines thereafter, arbitrator by his order, 20th February 2005, rejected the application.
Yes.
It is not in dispute that the award was eventually stamped and sent on 13th March 2005. My original award. Petitioner claims that the date on which he received the original award was 13th April 2005. Present petition under 34.3 was filed on 4/7.
So that was within time. According to that, since it was.
What the Delhi High Court has held, in my most respectful submission.
What is the.
Per incudium. Kindly consider paragraph 13.
1-3.
Yes, because I read, Your Lordship, original award was served not on 18 January. Only copies were given because there was no stamp. So there was no service.
Yes.
At all.
That is why that date was not reckoned. So,
therefore, according to my submission, the date when the original award was served, that is 13th April, should be reckoned.
That was within time.
That was within, but kindly see what it holds here.
Paragraph 13.
13.
Yes.
Kindly keep 3-4 lines starting with the award's executability. Now, analogically.
Yes, yes.
Analogically, in the case of an arbitral award, the validity can be questioned in proceedings under 34.3 of the Act. The award's executability is postponed in such cases as is evident on reading of 36 of the Act. However, in both instances, award and decree, and since the effect of an award is that it amounts to a decree under the new Act is the same. Therefore, this court is unpersuaded by the arguments on behalf of the petitioner that the correct date for considering it receiving the award under 31, whenever it is, was 13th April. It was in fact 18 January. This cannot be accepted. But I will give your Lordship the judgment, which is the Supreme Court judgment regarding this service.
18th of January means when it was announced.
When it was announced. There was no stamp paper also. How can it be an award? Well, for your Lordship's reading, probably your Lordship knows, kindly have a look at this judgment, which is actually the summarization of the law relating to service. 2011, Volume 4, STC 616. This was exactly that case which I said that The arbitrator,
616.
yes, arbitrator did not serve the original award. I got it from a execution petition levied in the execution court by the award holder.
Time cannot start running from
Time cannot start running from the service of a copy of the petition by the award holder. Under 31(7), the original award bearing the signature of the arbitrator has to be served on the party, not even on the advocate.
parties.
Because the judgment, another judgment is there, which says advocate's relationship with the party ends upon the conclusion of the arbitration proceedings. Section 32 provides with an award, the proceedings come to an end. So the contract comes to an end with the advocate. So you cannot serve it on
the advocate.
And it is party. This judgment also considers another judgment that is applicable in respect of government enterprise. Say railways. My contract is with Eastern Railway. The
17.
17.
Yes.
It is clear from a plain reading of section 34(3) that an application for setting aside of the arbitral award may not be made after a period of 3 months, either from the receipt of the arbitral award or in case where a request has to be made under section 33 within a period of 3 months from the date on which the request is disposed of. Similar, this is how the Delhi High Court reads it. Para 19. Lord kindly comes to 19. There is no ambiguity in the language of 34(3). Even if a request for correction under section 33 of the Act is made by a party before the tribunal, the period for the counterparties to make an application of 34 Act would also commence when the request is disposed of.
Yes.
19 holo, 26. Kindly turns over, my lord, to 26. Here, my lord, it deals with these facts of the case. 26, 27 need not, my lord, bother your lordship in those facts, my lord, because the second application was made, so it had traveled beyond the 39 H order. Lord, paragraph number 39.
Yes.
This court is unable to accept the view that the question whether the limitation would run from the date of disposal of the application under section 33 or from the date of receipt of the award is contingent upon the arbitral tribunal's decision of the said application. It is only when an application under such and such is disposed of that the parties are finally certain as to the content of the award. It is apparent that the rationale for providing that limitation would run from the date of disposal of the application is to provide a reasonable time to the parties to take steps for filing section 34 after they are certain as to the final shape. Clearly, this cannot be contingent on the view that the arbitral tribunal may take in respect of the merits of the application of 33. Now, this answers your lordship's query also and the argument of Mr. Sen. Mr. Sen has argued that, my lord, until and unless I come to know about the decision, what will happen? But your cause of action that I have lost in the matter, that remains, because arbitration in section 33 cannot change the award. It can only pass an additional award. It can make changes with respect to arithmetical disputes or, my lord, interpretation.
Yes.
In my case, my lord, this is apt on the fact of the case. So, my lord, this is the rationale that outcome of section 33 is not dependent on, my lord, rather filing of section 34 is not dependent on section 33's outcome. He knows what is the outcome, but the change is required. That's why no additional time is granted. It is only the disposal that is granted. That is also time bound. Now, if what has fallen from your lordship happens, then 33(6) has been provided. The arbitrator has to exercise. Lord, kindly comes to page 45, the last.
Paragraph 45.
Yes, I'm sorry. If a party harbors a bona fide belief that there is an apparent inadvertent error in the arbitral award, which requires correction, the application filed by the party under section 33 must necessarily be construed as such, notwithstanding the fate of the said application. It is possible that on a detailed examination of the contents of the application, an arbitral tribunal or court may find that the relief sought cannot be granted. The arbitral tribunal may find that what is claimed to be an inadvertent error is not so. But that does not mean that the limitation would run from the date of receipt of the award and not from the date on which the application is decided. As noted herein above, the period of limitation for filing a petition under section 34 of the such act runs from the date of decision of 33, not only for the said applicant, but for all the parties to the arbitration as well. It would lead to uncertainty if all parties are required to second guess the outcome of the application for calculating the period within which they may file the petition under section 34. So that answers, my lord, the arguments made by Mr. Singh.
Yes.
This is Delhi in 2021. Rather 2022, the latest judgment, even after what has been shown to your lordship. This is on 16th of November 2022. Now, my lord, the Supreme Court in 2018. একবার দেখ ফলো করো কি বলছি নিজেরা বের করো
What is the citation?
2018 SCC online SC 3181.
2018 SCC online.
Online 3181.
3181.
3181.
Yes.
পেয়েছি আরেকটা কপি This is Ved Prakash Mithal and Sons versus Union of India. This is a short judgment. May I just indicate? 2018 SCC online SC 3181. In the present case, not second paragraph. In the present case, an arbitral award was delivered on 30th of October and received by the response Sachin. An application to correct the said award was made on 16th of November 2015. We may add that a similar application to correct the award was also made on behalf of the respondent number such and such. Both these applications were decided by Lanera together and dismissed on 14th of December 2015. On 11th of March 2016, objections and application objecting to the award was filed under section 34. The only question that arises is whether the aforesaid 34 application could be said to be within the time mentioned in 34.3. The district judge, by order dated 30th of May 2017, found that the application was time barred, reasoning that the application should have been made on and from the first date, as in fact there was no correction made to the award. The respondent preferred an appeal before the Honorable High Court, whereby the learned single judge, by his judgment, such as reversed the order, stating that as section 33 application had been disposed of only on 14th of December 2015, the period mentioned in 34.3 would start running only from then, in which case the 34 application within time. The learned counsel appearing for such and such appears before us has argued that the expression disposed, which is mentioned in 34.3, would have to be read in consonance with and harmony with section 33. So read, this would only mean where some positive step has in fact taken place under section 33, an award is either corrected or modified. This could not possibly refer to an award which is not ultimately corrected or modified, and the application under section 33 is merely dismissed. For this, he relies on such and such. 7. Para 7. We are of the view that judgment of Bombay High Court does not reflect the correct position of law. Section 34.3 specifically speaks of the date on which the request under 33 has been disposed of. So, my lord, Supreme Court says it is only on the date of disposal, irrelevant for the fact to be considered with whether it was allowed or rejected.
So it approves the Delhi High Court view.
Disposed of.
No, it approves the, kindly come to paragraph 8. Bombay High Court view has been
Yes. Amit Suryakant.
accepted. Delhi High Court view has been accepted. Where is the Delhi High Court's view?
The Delhi High Court view.
Where has it referred to here?
No, Delhi High Court view has been affirmed.
Because paragraph 8, in our opinion, the learned single judge of the High Court, sorry, the impugned order.
Impugned order. Because the trial court had dismissed the application.
Yes. No, I was of the view that Delhi High Court judgment has been
Impugned
referred
order. So, my lord, again, the Supreme Court also stamps on it. That is only on the date of disposal. You cannot travel here and there.
Anything more?
Lord, prescribed period of limitation that's being mandatory that I did not show, my lord, that your lordship knows.
Because this is the only issue.
Yes,
What
yes.
is the effect of section 33 disposal on the
Absolutely,
limitation?
absolutely, absolutely.
So those are prescribed period, cannot be extended.
And with respect to the judgment cited by Mr. Sen, Lord, with respect to
Which
the
judgment?
Delhi High Court, judgment is cited. Okay. 2021, SEC Online Delhi, Lord, the one on 227 that Mr. Sen had cited, Lord, to that, that was within the scope of that 30 days the court had allowed. Here I say the extension is being granted beyond that 30 days. That is where, my lord, the jurisdictional error has happened. Because if I consider 14th of October, then
Straight follow. So according to you,
yes,
beyond that jurisdictional layer, 227.
yes.
According to you, that is inherent lack.
And Lord, Deepak Polymer is there. And also an argument was made, Lord, before your lordship's predecessor in this court. Lord, that honorable judge, my lord, had a view that everything is appealable. Under commercial court, everything is appealable. You have to go to appeal. So, my lord, one of the matter was also sent for appeal. Justice Tandon in his division bench had clarified that to judgment, I think. Had
This issue?
On this issue?
No, whether appeal or revision?
Yes. Clarifying that, I'll just art a copy. No, this is
unreported.
Unreported. I shall
copy to Mr. Sen.
Odisha Slurry Pipeline Infrastructure Limited versus IDBI Bank Limited. Dada.
Yes.
Lord, paragraph. এই প্যারাগ্রাফই দেখা যাচ্ছে না এই 13 considered. Lord, page 21, your lordship comes.
Yes, section 13 quoted.
13 quoted. Thereafter 22, it is no longer res integra, Lord, only under 43 the appeal will. That is the section also, and our division bench has held. So, my lord, appeal does not lie. Now, my lord, to sum up.
Yes, against the other orders, appeal does not lie. That is section 13 says.
Now, my lord, with respect to this limitation being very mandatory and, my lord, very clinching, the issue is the same thing fell for consideration in section 7.2, my lord, extension being passed, or, my lord, in under the Income Tax Act, my lord, section 263 is there, where, Lord, a particular appeal, when the reassessment or review can be self-generated by the department. Even there also, Lord, the term used was order made. The Honorable Supreme Court was pleased to again hold that order made and served or disposed of, these are all different things. So, Lord, order made and disposed of are to be read in same conjunction. And only because he could not appear, why nothing will be considered after, Lord, the 7.2 judgment is clear by the Honorable Supreme Court. Now, my respectful submission, if they are out of that 30 days because of this 14th of October, then, Lord, this...
Out of 30 days, you may have a case.
Yes.
But according to Mr. Sen, he is within 30 days.
Look, for that, the only issue that your lordship has to decide whether 14 or 17. If he falls within 17, I am out of court. If he falls within 14, then he is out of court. So, my lord, my argument, my submission with your lordship is, my lord, 14, the reason is it is disposed of.
According to you, the date of disposal, 14, that is to be taken into consideration.
Yes.
According to Mr. Sen.
And whatever the consequence, when signed, when communicated, irrelevant.
Certain other directions contained in those order, it is to be 17th is to be taken.
Yes. Absolutely.
Anything, Mr. Sen, with distinguishing these judgments?
Yes.
The subsequent judgments.
First important thing is none of these judgments are on the aspect that there was a mandate by the arbitrator to circulate the order under 33. In all these judgments, 33 disposed of on a particular date, that was the date of knowledge. No disparity between date of disposal and date of knowledge in respect of 33 factually. Court was not in session of a matter where the date on which the order was disposed of was not known to them. Parties were aware of the order on this particular date. In this context, kindly read this judgment. Now kindly come to what is the point in the Delhi judgment.
Delhi is 2022.
Yes, 2022. The subsequent.
Yes.
First one I've already dealt with.
Yes, yes.
That is absolutely per incurium. Now here, kindly see paragraph 5, 6, these dates. Award was made on 2nd of July. Paragraph 6.
Yes.
Petitioner claims he received it on 11th of July. Present petition could be filed within a period of 3 months from the said date, that is 11th October. However, on 1st August, Nirmal Singh, arrayed as respondent number 35, filed an application under 33 of the Arbitration and Conciliation Act. This 33 application was dismissed on this date. Paragraph 24, third line. Arbitral tribunal heard the concerned parties and passed an order dated 20th November rejecting the said application.
So on the date of hearing, order was passed.
On the date of hearing, the order was passed. And order was in the knowledge was also on the date of disposal. But still, this is not the question. The question is here, the main petitioner raised the issue that since 33 was dismissed as not maintainable, then you will have to take the first date of the service of the original award and count 3 months and 30 days from the original award. Date of disposal of 33 becomes redundant.
Since it has been dismissed.
Dismissed as not maintainable.
Yes.
This was the important question. Here, Delhi High Court observed whether 33 is maintainable or not maintainable, dismissed or not dismissed. The date of disposal of the request has to be the date. Once a 33 is on board, then the original award date loses. This is the ratio. So it has no nexus or connection with our point. Our point, again, if I frame our point is where 33 order has not been passed in presence of the parties and the arbitrator directs that the order be circulated in such special facts, whether date of disposal of request can be taken or date of knowledge has to be taken, because disposal must be made equivalent to knowledge having regard to 34, because 34, the law says, the statute says, and the judgment say that your time starts running from your knowledge. So in 33, where an order has been passed not in my presence, not in their presence, reserved, and passed on one day, thereafter circulated. It is not their case that on 14th they also came to know of this order. So where the order is passed later, then the disposal of request has to be interpreted keeping in view 34, 31, 7th together. Same manner as 34 provision has been interpreted. So this Delhi High Court judgment also does not decide our point that date of disposal has to be considered even when order is circulated and brought to the notice of the parties on a subsequent date. This is not the ratio. It only decides that irrespective of whether 33 is maintainable or not maintainable, once 33 is on board, then the date will be from the date of disposal of 33 and not original award service. This is the ratio of this judgment. 2018, which my learned friend cited now, this is also on that issue, not connected with our case.
Disposal or allowing?
But here, kindly see one thing. Dismissed. Here also, paragraph 2, your Lordship will see.
Paragraph
2.
Yes.
Of 2018.
Yes.
both these applications, that is the applications to correct,
Yes.
were decided together and dismissed on 14th December 2015. So the contention which was raised that since 33 is dismissed, therefore original date has to be taken. On 11th March, objections and applications objecting the award was filed under 34 by the respondent. Only question that arises is whether aforesaid 34 application would be said to be within time mentioned in 34(3). The learned district judge by order found that the application was time-barred, reasoning that the application should have been made on and from the first date. So the district judge proceeded on the basis that original award date should be taken into consideration.
Since it was dismissed,
Since it was dismissed. So
because the order was not modified.
order was not. So court says no. Once 33 is there, so the date of disposal of 33 has to be considered. There is no issue regarding
Because it carries meaning. Otherwise, it cannot carry any meaning because application is pending.
application is
Unless and
pending
until
your
it is
time will
disposed
start
of,
running from
no
first
one can
day.
contemplate it what will happen, whether it will be allowed
So
or
we have not an issue on this proposition here. Our issue is slightly different in view of arbitrator's order.
Yes, so according to you, your case has two distinctive features. One is not decided on that date
Not decided on that date.
or not disposed of.
Not
The
disposed.
language
Yes.
we can borrow,
Yes.
not disposed of on that date. Hearing taken, disposal on a subsequent date,
Subsequent date,
thereafter communication.
thereafter communication. It is like award. Award is reserved, published on another date, but publication date is not relevant. It is the actual service date which becomes relevant. So I say that the same analogy has to be drawn in case of, particularly my case, where the pronouncement and public and service is similar in case of an award. So where the statute has given a different meaning to disposal, where reserve judgment and pronouncement judgment is on different dates, but pronouncement becomes immaterial until communication. So same analogy should apply in this case also. These are my suggestions.
Your counterpart was nodding his head in this way when you are getting this.
Has to be. We can't accept like this. This will be admission by concession by conduct.
Yes. Heard Mr. Kormokar, learned advocate for the petitioner, and Mr. Sen, learned senior counsel representing the opposite party. Hearing stands concluded, judgment stands reserved. So again, from which date?
Not on receipt.
Order not passed,
Not on
not
receipt.
disposed of now.
That this is something very peculiar to this act, because no other act indicates this kind of a thing.
Yes, yes.
Date of
That-
receipt, date of disposal, no other act.
No, in
Means
other
all
cases,
other acts,
uh,
they say the
Mr. Kormokar will be
authorities can-
finding from the date of receipt of the certified copy.
Yes, that
So
is the usual.
that is
That
the
is the
receipt.
usual. That is the peculiarity in this act.
Yes, but here in these cases where these awards are communicated,
Yes.
so it's the original award which is being communicated, not a copy, not a
No,
certified
that's,
copy.
no, that's why the
Not the
difference.
certified copy which is being,
That's the
given
reason
here.
why the difference in
and in
the
many cases you will be finding that from the date of the order, those orders are communicated, like in the orders passed by the authorities,
yes,
they are
yes,
communicating.
yes.
Though if you are challenging in 226, there is no limitation as such.
No.
So no one is bothering when you are receiving that.
But in case
Otherwise,
of
the
building
principle
tribunals,
is the same.
in case of building tribunals, we have to file a section 5 explaining, although we have received it late, but we have to explain the delay in building tribunals.
That is from the date of the order.
Date of the order. But here it is peculiar. The act says differently.
But there in the building tribunal, I think there is a power to condone.
Yes, yes.
Here there is no
There is
power to condone.
No, that is the rigor of this
Power to
act.
condone is there.
Nothing
That is,
matters.
yes.
So
Nothing
that's
matters.
the
But
rigor
it's a
of
There
this
is no
act.
power to condone.
30 days. 30 days window.
30 days is the original. Mr. Kormokar,
But
30
whenever
days is from the original.
No.
When it gets modified,
Then also from the date of disposal, again 30 days,
Yes.
90 plus 30.
Yes, so that is 30 days. So here happens, if the communication takes a time, what will happen?
No, takes time. The provision is there. I have read it to your lordship. Lord. The provision is there. If the
What?
difference is there, the provision is
But extended.
30. No requirement because it is within 1 month.
32.6 or
33.6.
33.6. 33.6 I have seen. I will give my interpretation on 33.6.
Very well, Lord.
33.6 is not for that what we have said. It's
Lord,
for other.
2 and 5.
That will come in the order.
Let something be
33.6 is
resolved. Let something be resolved.
33.6 is not on that. 36.3 or 33.6 answers to the some of the queries raised by Mr. Sen in course of his submission. That answer is there.
May I take back the book?
Yes, yes. So that I will consider. So this is an
Great.
interesting
Yes, very
point. It's an interesting point after all.
But try to, Lord, do justice
No,
to
no.
my client. Let's see
No,
what
because none of the judgments both of you have cited deals with this
There
particular
is none. There is actually
none.
none.
There is
this
none.
fact situation.
I do not know, Lord.
What happens? Arbitrator sits. Then
On
and
the
then
same day.
they win their case.
Typographical and other corrections, it's usually on the same
On
day
the same day. The same.
because the nature of the
Ah.
scope of section 33. So that is to be considered.
That was what the statute legislature also had in mind. That is
No,
why this was-
interestingly, there is no judgment available on
Yes.
this point.
No, no, it
Lord,
is
I failed to get one.
That makes the task difficult.